Hi, this is Attorney Mike Graven coming to you from Chicago, as usual, a little bit early, because I jumped my timer. But I've got Arty's Corporate Fiction with me here, who does not seem to be um, uh, swayed. Oh, God.
I'm gonna say here for the record, I have 7:02 now on my clock, so
Yeah, I get that. But when I set this up, it gives you a little backwards timer, you know?
Yeah, but sometimes you got to refresh the browser to get it resynced again.
Is that what it is?
Probably, yeah.
I need to figure all this stuff out. All right, so we've got a new video from our Nevada judges and Alex, and he's got all sorts of cool stuff going on out there too. He set us up with the judges, but there's like more coming. There's going to be some neat stuff coming down the pike there. Number one. Number two, Arty's putting together a deep dive of this case, and there is so much more than I'm covering. It's ridiculous. Like, I already know about it. I'm not even going to go there. I want to do that over on his channel. It's going to be fun.
Yeah, we're just like I said in yesterday, just like with Blendino, I intend on at least giving you a fairly significant backstory. I know that our Nevada judges do have footage from their civil issue dealing with the trust of the family trust, because that's kind of like a precursor to all of the mess that's going on today. But I'm not going to show that video. I might show some highlights because there are some spicy moments dealing with the sister's attorney who kind of goes off the rails actually a little bit. But
cool.
Beyond that, I'm just going to go through a factual narrative from one of his lawsuits that he filed, and the district court does a good job of giving you us a factual narrative as a background, and I'll be going through that in part one.
That is really cool. All right. Well, let's get this party started. If you're paying attention here, I'm going through our Nevada judges playlist on this topic. I did 2 videos in one, in the first one because they were short. This, if you're scoring at home, old ESPN joke. If you're scoring at home, it's number 4 on that list. And I only say that because I cut chunks of it out because I didn't think they were good for our purposes. But it is interesting, and I would recommend it. All right, let me get over here. There we go.
This is the State of Nevada versus Roger Hillygus and Stuart Handte, case number RCR 2019-103468. A and B. Counsel, please state your name for the record.
My name is Amos Stagey. I represent the state of Nevada through the Washoe County District Attorney's Office.
Your Honor, Tom Pitaro. I represent Stuart Handte. Also with me in the back, as you can see, is Attorney Ozzie Fumo in the firm, and off to my right is Kendall Strong, who is another attorney sitting in here. I don't think you can see her, but she's just sitting during this time.
And do we have both of the defendants with us on Zoom today?
I'm sorry?
Hillygus is here representing Roger Hillygus, the criminal defendant.
I mean, this is minor. Arty, we were just talking, and he was saying he listened to a lot of this stuff, so you might not have seen this. Of course, Hillygus is top right. I mean, look at that. Like just the blazing sun. Like I don't even see a human form.
Is that a cryptid? I don't. That looks like some found footage, that you see in a top 5 scary YouTube videos thing.
Oh, it's good, and the judge addresses it.
All right, and do we also have Mr. Handte present?
Oh, Your Honor, as he is present, be excused.
All right, I will excuse his presence for the purpose of the pre-preliminary hearing. And Mr. Hillygus, I'm having trouble seeing you. There is a very bright light, and I can only see half of your face, and you have glasses and a hat on. If you could make some adjustments so that I could see you a bit better, I would appreciate it. Okay, that's a little bit better.
Can you see me now?
I can. The hat and the glasses make it difficult, but you're blocking some of the light, which is better.
They're reading glasses. I can take them off, and I can take my hat off if that helps.
All right, perhaps the hat, if you need your reading glasses, certainly you can wear those. All right, thank you.
I don't need the hat.
All right. And I notice we may have some other folks present on the Zoom call. Mr. Hillygus, my clerk has indicated that those are your secretaries. Is that correct?
That is correct, Your Honor. I've got 2 secretaries. I've got the 3rd secretary, but he was unable to make this meeting, the Zoom meeting. That's
Seriously.
correct.
All right.
3
So
secretaries.
I will allow
Man,
them to
must be
remain
nice.
on the Zoom for the purposes of the pre-preliminary hearing. They must mute themselves so that they're not part of the court record as they are not parties. And I will also note that the court has new technology that has very recently been installed, I believe as early as this morning, such that the court will have a YouTube channel which will be available for the public to view proceedings, since, as we are all aware, we are in the midst of the pandemic.
That is interesting to me. I mean, we're getting all this stuff because of Alex, and in fact, there's even more discussion. Maybe it's just because it's another room, but we have another discussion of access for our Nevada judges. But she's saying right here, we're putting all this on YouTube.
I mean, it's fun. It's funny to see these things happen. That we're now a year and a half later, and we're now seeing July 2020, back when this thing was started. People are getting used to this, and it's funny to see how things have become normalized now. That I'm getting recommended so many court YouTube channels now that are live streaming the proceedings.
It is funny too. That's one of the neat things right here. They try to do scheduling, and she does exactly what the judges I was in front of what we're doing, which is like, oh yeah, let's sit this out 3 months. Hopefully everything will be better by then.
Yeah.
You're like, oh no, honey, I'm here from the future.
Oh.
It's not better then.
Oh, you sweet summer child! If you only knew.
Thank you, Miss Lanny. My favorite attorneys. Always a good time. Aww.
Court is still not open to the public, so this will be a way for the public to view the proceedings as they have a right to do. And we need to discuss a couple issues today, counsel, and one of them is whether there is a request to hold these preliminary hearing in person in the courtroom versus the presumption currently, which is that all preliminary hearings are conducted remotely via Zoom, with all parties, defendants, and witnesses being present remotely. Again, the system that we have in place through the court is that the Zoom is directly captured by our JABS system, so it is part of the court record, the same as if the parties were present in court as far as our JABS system goes for making a court record, just so you know. So that's one issue we have to discuss. And then the next issue we need to discuss, which I'll take second, is the request for the news media coverage. So first, counsel, let's talk about whether is there any party that is requesting to have this hearing held in person as opposed to the presumption that is currently Zoom. And I will begin with Mr. Steggy. Go ahead, Mr. Steggy. And I'll return to you, Mr. Steggy. Let me give Mr. Hillygus an opportunity to state what he would like to regarding the issue. Mr. Hillygus.
Yes, Your Honor. For the record, I would object to this hearing, this preliminary hearing,
Of course.
as being a violation of the rules of criminal procedure. The email that I received from the clerk of the court is not a proper motion. Anytime that a party intends to extend or shorten the time in a court, it is to be done by a motion. There was no motion.
I love this. It's just wrong. No, courts can set dates. They don't have to do it via motion. And this condescending to a clearly very bright judge about how court procedure works.
I had to go think back to myself. No, he got that from a court secretary, right? That set the date,
Right.
not another party. What the hell is he talking about? The court doesn't set a motion.
No, the courts don't file motions. The parties file motions, right? Yeah.
Yeah, it's like
It's just wrong. And then the condescension, like, oh well, here's how it works.
Of
To
course,
a judge,
yeah.
come on. I absolutely love this judge. She's got that sweet feminine voice, and she just dismisses all. She's like, yeah, that's something. She just never engages it. Or once in a while, she'll just be like, no, I'm ruling against that, very calmly. And she's just really cool. P. Barnes, $10. 3 secretaries. One is responsible for vowels, the second for consonants, the third is backup.
In this instance,
Thank you.
There was just an email by the clerk of the court. There was no time frame on how long I had to respond. A decision was made within less than 48 hours before I had time to respond that this hearing was going to be set. So, for the record, I would object to this hearing as being a violation of the rules, a violation of NRS 174, and a violation of my rights as a criminal defendant in this case to be forced to come to this preliminary hearing, which.
Thank you, Gia. That's very generous, and I don't even want to know about the backside of that super chat.
I want to keep this live stream monetized.
Is not even a proper hearing. There was a preliminary hearing set. It had been changed numerous times.
Thank you, Vincent.
And once again, it looks like that hearing is going to be changed. As far as the hearing that's going to be set for the 31st, I also too object to a Zoom meeting of any witnesses. The Sixth Amendment, the Confrontation Clause, provides criminal defendant the right to face his accusers in a court.
Thank you, Ndaka.
Oh my God.
That setting is a lot different for a witness to appear next to a judge in a witness stand with a bailiff present, with a jury present.
Oh, do tell.
With persons in the gallery present. And with attorneys questioning people and witnesses being questioned face to face is also a right of a criminal defendant.
I cut a lot of this because he's wrong. He's got one good argument in here. Under the Sixth Amendment, you've got a right to confront your accusers, and that does carry some weight. It carries some weight at trial. Everything else he's saying is garbage with respect to all this, and even the public access is taken care of by the media request and the YouTube channel.
Well, to be fair, to be clear, it's the text of the amendment says to confront the witnesses against you.
Mm-hmm.
And oftentimes I get into arguments with sovereign citizens a lot because they always say, "Let me face my accuser." Well, that you mean witness, right? Or the victim. Let me face the victim who is accusing me. Well, it doesn't need to be a victim. There need to be witnesses who witnessed you commit a crime. You know what I mean?
Right.
But yeah. I mean, and I agree with him in that respect. Yes, you're right. He has the right to confront the witnesses against him.
At
trial. Yeah.
That's it. Now, during the pendency of a case, a judge could say, well, I want to make sure the witnesses are here at a preliminary hearing and order it.
Right.
But you have no Sixth Amendment right to it.
Right.
You don't. So
at least
it is interesting. They did it. I was hoping they'd have a better discussion. They didn't. It wasn't like bad. It was just, but it's just sort of a hearing. And I cut most of it out because it really got long. Thank you, Vincent.
And therefore, I would also object to the 31st preliminary hearing being set as a Zoom meeting. Thank you.
Mr. Steggy?
Thank you, Your Honor, for returning to me. I want to respond or echo some of Mr. Pitaro's
Thank you, Smarty Marty.
Statements. While his position is accurate that we have to consider if this case goes to district court, it really has no place to go because jury trials in district court are put off at least until August. Both of these defendants are out of custody, so their district court trial, if there were to be one, is far off.
Thank you, Secret Squirrel.
Of demeanor and also sort of responding to Mr. Hillygus' comments about wanting a bailiff there, the witness to sit by a judge and people in the gallery. I don't know that
reciting Kim now.
Supported,
Thank you, Angry Drunk Bumblebees.
principles, the constitutional right of confrontation, it's a trial right. There is case law interpreting sort of what physical confrontation means.
All right, thank you. So certainly we are in
Thank you, Pamela.
unprecedented times.
Hillygus and
I don't
Handte.
think it's anyone's preference that we conduct hearings remotely, but currently that is the reality of the situation in which we find ourselves. Given the statements by all parties present today, I will consider continuing it one more time in the hopes that perhaps the next continuance, if things in the community are better as far as the COVID-19 situation.
Yeah, right there. That's what we were just talking about. Like that she has. I mean, she doesn't know. She's living in that moment.
I mean,
but
yeah, I know.
it's not getting better.
Yeah.
Yep. Thank
And
you,
that
Deacon.
the preliminary hearing could be conducted safely in person. I'll continue it once more. But I am not likely to continue it yet again if at this date, and I'm thinking perhaps 3 months of a continuance in the hopes that at that time, perhaps Nevada will be out of, I believe Washoe County is currently in the yellow list, so to speak, and Clark County is on the red list, so to speak. Perhaps by that time, we would be at least out of those zones such that compelling
Thank you, Dr. R. Martin.
witnesses who have no choice whether to come to court or not, they're hereby subpoenaed, to compel them to come here, it would be a safer time in our community to do so than it is next week, essentially. So, counsel, I will give you an opportunity to communicate with my
don't tell
clerk if
anybody,
you would
Fulton.
like, and amongst yourselves,
Thank you.
as to a date potentially 3 months down the road when we could attempt to have a discussion. And I'm going to set another preliminary hearing. I'd like to set it 2 weeks before that preliminary hearing. And I know Mr. Hillygus has objected to such a procedure, but I believe under the emergency circumstances we're in, it is a necessity to have these preliminary hearings.
Hey, Taco.
So that, again,
Yes.
we can
About right.
discuss the state, whether parties are ready to go forward, and if it's safe to have all these parties present in person in the courtroom. And so then the second issue we need to discuss is there's been a media request from our Nevada judges to, I believe their request was to live broadcast the preliminary hearing, to record and broadcast that. So I'll allow parties to be heard briefly. Again, it is the court's anticipation that will be that all proceedings in this case, as in other cases, will be available via our Zoom channel. But I'll allow parties to be heard on that, or not our Zoom channel, our YouTube channel, excuse me. I'll allow the parties to be heard. Mr. Steggy?
If that is the case, if the proceedings are going to be on YouTube, then the request is moot. I'm not sure what portions of it constitute the proceedings when it would start being broadcast. For example, we were all here before Your Honor took the bench. Not certain that is where that falls within the proceedings.
That does not.
Or how we might conduct bench conferences.
So there are ways we can do this, and it does not start recording for the YouTube channel until the judge takes the bench. So any preliminary things or the judge is out of the room, that is not part of the dialogue.
Thank you,
Also,
Gwen.
there are ways such as
Glad to see you.
breakout rooms on Zoom, parties can mute themselves on Zoom that obviously will not be recorded. And we have ways, I believe, in at an actual preliminary hearing as opposed to this preliminary stage, I would think we would have the assistance of one of our IT staff with us in court, such that if those things needed to happen confidentially, we can ensure that the parties have that confidentiality if they need to, and that bench conferences are recorded and part of the court record, but not broadcast on the YouTube, if that answers some of those questions.
Thank you, Shelby. And I have never been accused of being too nice before in my life.
Wow.
That is fantastic. I'd like to give you a big kiss for that.
Thank you.
Thank you. Mr. Pitaro, you'll need to unmute yourself, Mr. Pitaro. I can't hear you.
There we go. For some reason, I made this miniaturized and I can't get it big again, so it's a little tiny square now. On the, obviously, if you have the YouTube channel, the way that is, that's going to be a fixture of the court, I assume, and that will be the official court record.
On the issue of the media request, it's my understanding that our Nevada judges had.
Yeah, I cut off the defense attorney there because he rambles, and there's nothing bad. It's just that they sit there and go through the mechanics of Zoom
Yeah.
and how it's going to work going forward, and it goes
Yeah.
on for like 15 minutes. It's rational but boring as all get out. So I just moved on.
Placed a request to be able to stream the audio of this preliminary hearing. Is that what your understanding is? That they put in a request to live stream the audio of this preliminary hearing right here today, and
Thank you,
also to be present with
I'm not sure I know about
cameras
the
and
Streisand
audio
effect.
video in the courtroom for the preliminary hearing, whichever that date will be. And I'm in agreement with having the media, whichever media it happens to be, providing for a public hearing and providing the public the information that's being disseminated from the court.
All right. So what our Nevada judges had requested is they wanted to, and I'm reading directly.
Again, a little too long, but no big deal. The only thing that that defendant doesn't have a problem with is media. He apparently wants the media there. The only time he can answer a question, it's the only time he can be straight. Yeah, that's fine. Our Nevada judges is fine. Go ahead. Very interesting.
From
Notoriety.
their request, record only the hearing scheduled on July 22nd, that's this hearing right now, and to record and broadcast live the preliminary hearing scheduled for July 31st. That's what their request states. And whenever there's an objection to the presence of the media, as there was, we hold this hearing first to hash that out. But what I will find regarding the media is I will allow our Nevada judges to record and broadcast live the preliminary hearing whenever that may be. I will agree to that. And I believe the public has a right. Again, that's why the YouTube channel is being put in place, since the public's not able to be in the courtroom. This way the public can still have the right to view the proceedings. So I will grant the request
Great,
from our
Amanda.
Nevada judges.
Thanks, Amanda.
And Mr. Steggy, I think your suggestion of some status hearings is a good one, and I'd like to implement that. Counsel, when would you like to set, we can set it right now, the first status hearing to discuss the case? And Mr. Steggy, what I'm going to do as far as
I
the
like that.
witnesses is I'm going to hold them to the July 31st subpoenas, but I would like them to be reserved once we're able to settle on the actual preliminary hearing date.
I'll defer to Mr. Pitaro on the picking of dates.
Your Honor, about 30 days?
That's fine. Let's look for a date 30 days out. Mr. Hillygus, will that work for you for a status hearing?
30 days for a status hearing, Your Honor?
Correct. Will that work for you?
I'm in agreement with that.
For the
Okay,
record, I was
thank you.
able to
The clerk will
recover
make the
them.
date, and we'll let you all know in just one moment. Anything
an
else from
inside
Mr.
joke.
Hillygus or Mr. Stagey?
I do have
9,000
something,
sold.
Your Honor. It's a question of law.
Go ahead.
It's my understanding that this court has taken subject matter jurisdiction. But NRS 189 states that the Justice Court does not have subject matter jurisdiction over this case.
Here
This
we
case
go.
is a federal case, as stated by Allison Jenkins of the Reno PD. This case
Okay, so his argument, he's launching into this is a federal case. No, it's not.
Okay.
You were charged by a state prosecutor in the state of Nevada, and you are in a state court. Now,
Yeah.
might there be some arguments that you cross state lines that involve something? Sure, I don't know. I don't know what those are. But if you have that, you would file a motion to remove to federal
Mhm.
court.
Right.
What you're doing now is not convincing anybody. He says this is a federal case because a police officer said so. Okay.
case involves the postal inspector. This case involved the Social Security Administration. This
What?
case involves the FBI. This case involves the LA County Sheriff's Department. My mother was a resident of California. This is my mother. Their statement of fact, Your Honor, this is a civil matter. No controversy exists in this case. There is no injured party that exists. There is no victim that exists. There's no statement or complaint from the alleged victim, Susan, or either of her guardians or either of her court-appointed attorneys. So without a controversy, this court lacks subject matter jurisdiction. This matter is a federal matter. I've cited that in 7 documents that I filed with the court. I have not received a response. The district attorney is attempting to ambush evidence with witnesses that have not filed declarations, sworn statements. I've not been given a witness list. So at this point, once jurisdiction is challenged, it must be proven. And that's what I'm asking for this court to do.
This is pure soft sit.
Okay, so yeah, okay. I don't know how I missed this. I don't know how I missed this, but yeah, he is definitely taking a few bits out of the soft sit playbook here.
He's soft sit through and through, and what I think is he was soft sit from the get, but it did not show in the first 3 videos. It did not show just because it didn't have occasion to or what have you. Well, and he even did some things in the last video. They asked him, "Is your name right on the caption or something?" He said, "Yes."
Mm-hmm.
I'm like, that is not soft sit. But overall, everything he's saying here is straight up. There's no controversy. It's a civil case. It needs to go to federal court. Blah,
well, removing to federal court a little bit. My thing is victimless crime, no injured party. No sworn statement. I mean,
yes, you're right. The removal is more sophisticated than the usual. Just the state courts don't exist. It's a dumb argument saying, oh, the postmaster's involved, the FBI's involved, the LA County's involved, so it must be a federal case. Well, wrong. It's a Nevada charge for kidnapping in Nevada. You can have federal employees involved. You can have you can cross state lines, whatever. You've been charged with a crime in the state of Nevada. The end.
What part of his argument, and he's going to repeat this throughout the endeavor. Part of his argument about this sort of removal to federal court is the claim that he's making that his mother, at the time she was taken, the alleged incident, she was a resident of California. He's making that argument. I think his sister probably disagrees with that argument. And that's how he's trying to make the claim that he took his mother from a living home in Nevada and brought her back to California, where I think he was arrested. And so he's arguing that this is a federal case because his mother, even though she was taken from Nevada, she was a California resident, and therefore Nevada wouldn't have jurisdiction, or this is a federal issue because state lines were crossed.
Right. So that's less soft sit and just horrible argument.
Yeah, you
kidnapped a woman in Nevada. Yeah. That's what they charged you with. There are all sorts of other things that have occurred throughout your life in other states and whatnot. It doesn't make it a federal case. They're saying you took her out of a facility without the authority to do so. We're calling it kidnapping. It all occurred in the state of Nevada. A Nevada prosecutor charged you with it, and that's what you're here for. The end.
Yeah.
Yep.
Is to prove that they have jurisdiction, because I believe that this court lacks subject matter jurisdiction over this case.
Of course you do.
Thank you, Mr. Hillygus. The court finds this court does have jurisdiction to hear this case, and we'll go...
Right there, I think I'm in love. Right there, I think I'm in love. She lets it all play, and then she goes, yes, with that sweet voice, yes.
Yeah,
the court does find they have jurisdiction. Moving on.
Yeah.
Forward as we've previously outlined. So I will plan to see you all then for our status hearing. Mr. Steggy?
I'm sorry. There is a matter of discovery. If the court recalls, the original prelim in this case was continued on the day of when Mr. Houston withdrew from representing Mr. Hillygus. And among the reasons cited by Mr. Hillygus was a lack of discovery, claiming he had not gotten everything from Mr. Houston. I invite the court's inquiry into that matter and would add, additionally, that since that time, my office has reached out to Mr. Hillygus a number of times seeking to provide him with the discovery, none of which he has taken advantage of.
Thank you, Sandy. This is good too. Artie, you probably know this. He goes through and the judge questions, say, why didn't you take the discovery? He's sitting there shooting his mouth off. Oh, he's hiding evidence from me. He's doing anything. The prosecutor's saying, I've had discovery. First of all, I already turned it over to your first attorney. But he ultimately came around to my position and said, fine, I'll turn it over again. He won't go pick it up. So he just wants to sit there and accuse, make wild accusations against a prosecutor. And doesn't even know what's in the discovery because he won't pick it up. It's frustrating.
So if we get to the preliminary hearing or down the road, and that is a complaint, the state will point to this moment that Mr. Hillygus has discovery
The Blandino of Kim.
available from our office.
Thank you.
If he wishes to have it.
Are you aware of that, Mr. Hillygus, that the district attorney is offering you the discovery and you have not picked it up or received it yet?
Thank you, Sue
in
D.
the 7 documents that I've filed in the court that have not been responded to by Steggy, we've got quite a few questions of contested facts, of evidence. And the discovery, the first discovery, the 200 pages from the district attorney, we've admitted to that. But we've also explained that there's a massive amount of exculpatory evidence which is being withheld in this case.
Of course there
And
are.
so without a chain of custody, without them providing the evidence and a chain of custody of when they got it, who they got it from, who they sent it to, when that person got it, because
He's not entitled to all that, but yeah, you're right. Even that is just I'm missing a massive amount. Well, you don't talk in those terms if you actually want to get somewhere. If you have a good allegation, say, hey, I know that these 3 witnesses gave statements and I don't have them. Then the judge is going to look at them and say, what the hell's going on? They're going to ask that prosecutor, where are those statements?
Yeah.
But when you just say there's a massive amount that I don't have, and then the prosecutor says on the record, hey, I got a pile of discovery for you that you won't pick up from me or tell me how to get to you. You've lost all credibility. Yes, Deacon, thank you. And I don't know, Artie, you know more than me. I'm hearing a lot of this, but I'm literally just doing this as I go. And they say he's a real dangerous guy. I'm willing to believe that, but I haven't seen it yet because I've just seen these limited clips in court. I mean, that's not where you're dangerous, right?
Mm-hmm. I mean, I'm only going by, again, I'm still reading about the back history, but there is obviously a lot of bad blood between the siblings and dealing with his mother, which is the whole central,
Right.
theme about surrounding this case. I can't recall what I heard. I'll have to refresh my memory, but I haven't necessarily heard anything just yet. Just typical, condescension, obstructionists sprinkled in with soft-sit arguments, at least so far.
I don't even know if we'll see, but I imagine some facts are going to come out over this playlist. It's pretty long.
because I've not been provided with massive amounts of exculpatory evidence. This is a suppression, willful suppression of evidence that the criminal defendant is
Leanne,
required to have to defend himself.
we love you.
That is why this is a civil rights violation in a federal case. Mr. Steggy is attempting to backdate evidence. No witness has provided a sworn declaration. We've not been provided any of these statements. So they're attempting to ambush evidence and have witnesses come in and testify who I have not been given the opportunity
Thank you, P.
to
Barnes.
depose
It's
these
funny.
witnesses, which under Rule 31 of the Federal Rules of Criminal Procedure.
Federal rules?
Yeah, he cites the federal rules. And I thought about it, I'm like, that's so stupid. You're clearly in a state court. But I will say this, it's dumb. It's dumb as dumb can get, but it does fit if you really are generous. He thinks it should be a federal case. So it fits with his theory that, like, again, even if it is a federal case, then get it removed to federal court and have them apply the federal rules.
Steggy wouldn't be the prosecuting attorney if this was a federal case.
Right. So, so then he's setting the federal rules of civil procedure, and he's setting them wrong, of course, as they always, like, in the sense that he doesn't get what they actually mean. The usual.
Yeah, of course.
I am obligated to file Rule 31 written discovery questions to these witnesses. so that we can have facts
no,
and
you're not.
evidence that we're going to move forward when I question the witnesses.
So, Mr. Hillygus,
So as far as the evidence,
Hold on, Mr. Hillygus. Let me
got an
just
email.
interject.
He could have sent it by email. They could have sent me the discovery.
Mr. Steggy,
But
excuse me, Mr.
until they
Hillygus,
can
will
provide
you-
a
will
chain
you
of
hold on
custody
just one moment, please,
with
so
the
while I say
evidence.
something?
I can't hear you. I'm sorry.
Okay, can you hear me now?
You're
Now
talking
I can.
over her.
Okay, so, Mr. Hillygus, the only issue I'm addressing right now is Mr. Steggy has said he has discovery ready and waiting for you that you have not picked up. So that has been put on the record. I wonder why you have not received that discovery from him yet, sir. That is my question. Why have you not picked that discovery up that is waiting for you?
I've got an email. I've got a secretary. He's more than welcome to send any discovery as long as they provide a chain of custody, because there is the fruit of the poisonous tree doctrine
Oh my
that's
God.
going to be filed, because the probable cause statement and the affidavit filed by Alice.
They
It's
just
like he's
sound so
ad-libbing.
stupid
It's-
and don't know it. There's
It's like
fruit.
he's-
There's
he's-
fruit of the poisonous tree that's going to be filed.
He's ad-libbing like legal criminal procedure
Yeah.
jargon and just acting as if makes him sound smart.
Well,
It's
yeah, I don't see where there's fruit of the poisonous tree here. But if there is, you'd file a motion to suppress. That would be your basis for the motion. That's
Right.
fine.
But he's just vomiting out fruit of the poisonous tree.
Right. Fourth
chain of
Amendment.
custody. Chain of custody.
Yeah.
Rico.
Yeah. You need a chain of custody for evidence to show, for instance, if someone takes the, if they have a gun from the scene or drugs or
Right.
something.
No, I'm
But not
denying.
discovery.
It's just he's just vomiting it out and just like yeah.
And she knows, she's like, but she pretends to go along with it, but then completely ignores it and does the right thing immediately, but lets him say his whole thing first.
Jenkins to this court for a warrant for my arrest was falsified. There's been documents submitted to California that have been falsified, and we can prove that through a public records request with California.
Again, Mr. Steggy, Mr. Hillygus, if you would direct perhaps your secretary to receive the information from Mr. Steggy, I'm sure those arrangements can be made.
Yeah.
The issue is simply that there is a discovery waiting for you that you have not yet received.
It is cute how she pretended to go with his secretary thing. I like that.
I actually give her a lot of respect for not even entertaining like 90% of what he said and just focused on I can get my secretary to get it, and that's what she focused on. I appreciate that from her.
Absolutely.
Put that on the record, and I'm not going to allow that issue to force a continuance in the future. So I believe we've addressed it adequately on the record today. Anything further, counsel, before we adjourn?
No, Your Honor.
No, thank you.
All right. Thank you all for being present, and I look forward to seeing you all at the status hearing.
Well, there we go. I don't know what the next hearing holds, but I'm impressed with this judge so far. That's the other thing too that they're saying. I don't want to have these continuances and stuff. Again, the first thing I did was a hearing that was like 4 days ago.
Yeah.
And they're nowhere near trial. So it's even funnier for me. I mean, I'm used to it because it's also what's happening in my practice.
Mm-hmm.
But I'm like, oh, that's cute that you guys think that something's going to happen.
No.
Oh, well. All right. So if there's anybody left here who is not subscribed to Arty's Corporate Fiction, what the hell's wrong with you? Get over there and get it done. Once again, if you made it this far, you are in fact a law nerd. And the only way you can salvage yourself is to go over to Arty's channel, which is way cooler than mine. Okay?
Yeah, sure.
It's way more fun.
That's debatable.
All right. Thank you for coming out. I appreciate it. I don't know if you guys knew, yesterday he actually wanted to. We talked for like just a minute, but I could see the pain. Like, you weren't being a drama queen, but he's like, dude, I'd really like to or whatever. But I'm like, I could just see you like wince as you were like having that 1 minute conversation with me.
It was, I don't know what was going on. It was not pretty. Well, like Friday and Saturday, but I'm better now, obviously. So, I should be back to normal starting this week. So, as a final aside, on Monday, I need to confirm with him, but it's going to be another Law and Order episode with my brother. We're going to be reviewing a JCS interrogation, so that's going to be fun. And then sometime in the week, maybe Wednesday, is when I'll have part 1 of the Hillygus saga.
Yeah, that sounds awesome. I caught a little bit of you with your brother, and that's kind of fun too.
Yeah,
It's neat. It's neat both for the police perspective and the brother vibe thing, which is kind of cool.
yeah, I'm excited. I'm excited to see because this will be our first one dealing with an interrogation. So I'm excited to see how that goes. So,
All right, thanks a
All
lot.
right.
That's
Thanks a
it.
lot,
Good
guys.
night, everybody. Thanks for coming out.
Good night. Take care.